So once again, welcome to everybody on our webinar today, hosted by Bristows. I'm Robert Bond, and I'm joined today by Salman, Waris, and Michael Gold, and I'm going to introduce them in a moment. In the next hour, we're going to do a comparison between the laws in India, California, and the GDPR, and indeed everywhere else, because as we'll see, we're all moving not seamlessly, but generally in the same direction. So me at this end, many of you will know already, so I'm not going to say a great deal about me. It's already on the screen. I've been doing data protection for a good number of years, and at Bristows, we regularly do webinars like this. So if you enjoy this one and you've not been on before, please do look out for them in the future. Indeed, the next one we're going to be doing will be on subject access requests. So my good friend Salman, who I've known for many years, is in India and heads the TMT and IP practice groups at TechLegis. Salman regularly advises on a range of legal and regulatory issues in the IP/IT technology sector, and is highly recommended by the leading journals, Chambers and Partners, Legal 500, and so on, for his expertise in the area. And so I'm delighted that he has so kindly agreed to stay up late in his evening to take us through the law in India. And we're also joined from California earlier in the morning, his time, by Michael Gold, another good friend who I've worked with for years, who co-chairs the Mangels, Butler cybersecurity and privacy group. Michael deals with a lot of data incidents, is fully aware of the varying state laws in the US, and now, like other Californian attorneys, is facing the challenges of the new California Consumer Privacy Act. And maybe Michael will also talk about the likelihood of people like Tim Cook at Microsoft and others pushing for a more federal GDPR-style law, as we heard announced recently. So I did allude to the fact that we are heading inexorably in a similar direction, and it's not just California, nor indeed India, but also Bahrain and Brazil and Kenya, and other parts of the world who are in the process of enacting legislation that in many cases looks remarkably like the principles that we have in the EU law. And this is not surprising because, in fact, my rule of thumb has been, if you want to know what the law for privacy is likely to look like in a particular jurisdiction, think back historically to empires and occupations and so on, and you will find it is not unusual that the Argentinian law looks very Spanish, that the new Brazil law looks very Portuguese, that North African data laws are very French influenced, that Singapore, Malaysia, indeed India, do take on a very British style. And indeed, we in Europe are very heavily influenced by a combination of common law and civil law. Again, it's not surprising that we're seeing similar principles in, say, the South African law or the Russian law, because those parties have absorbed, or indeed in the case of Convention 108 for Russia, are signed up to these other global approaches to privacy. So even pre what California is saying, my understanding is that the US privacy principles were very much adopted from OECD guidelines and so on. And so we thought that this talk would be ideal to look at a quick comparison of where we are all heading. And so briefly, before I hand over to Salman, I think everybody has heard of GDPR. I think you're all aware that it has expanded the definition of personal data to include certain special categories like biometric and genetic data, but also philosophical, political opinions, racial and ethnic background, criminal records, and so on. GDPR applies to any controller and any processor of personal data if the parties are either physically situated in the EU or are offering their goods and services or monitoring EU citizens. So this actually takes us wider than I think we're going to see some other countries go. And my understanding is California does not affect every business, but we over here apply it no matter what size. And it is extraterritorial, the EU law, if the business has no physical presence in the EU, but is actively promoting goods and services into the EU or monitoring citizens. Our new law focuses more on the lawful grounds for processing, and it is not all about consent. We may hear in the media that it's consent, but in fact in the EU there are other lawful grounds for processing, like the vital interests of the individual, like legal and administrative requirements, the role of public bodies, and also legitimate interest, which has been a topic that we've done webinars on in the past, as it seems quite helpful for business to not have to always focus on consent. The idea of GDPR was to have not 28 member states with 28 different laws, but one law and a one-stop shop approach. In reality, that's not quite happening. The new mandatory role of the data protection officer is something we didn't used to have, but we do now. Focus on key words like transparency and accountability, not necessarily providing prescriptive legal advice from the law, but the law saying you, each business, must be transparent about what you do and must be accountable for what you do, right or wrong. And then the notions of privacy by default or privacy by design and data protection impact assessment, something new that is enshrined in GDPR. And of course, everybody's heard about the 4% of global annual revenues, although not everybody is going to be hit with that size of fines, but the fines have increased. And then we have a double blow in that coming hot on the heels, probably in 2020, is our e-privacy regulation that is focused much more on distance marketing, email, SMS, text, bringing social media delivery vehicles like WhatsApp, Facebook, Netflix into the role of the communication provider in terms of liability, and changing the emphasis from opt-out to opt-in, which is going to be the next big issue, I think, for both B2C and B2C organizations. And indeed, thanks to Cambridge Analytica, put in a quote from our European Data Protection Supervisor talking about the need to be more transparent. And indeed, the word ethics seems to have cropped up in the last week from the International Privacy Commissioner's approach. So it's not all about the law, it's about just because we can doesn't always mean we should. So that's where we are from the EU. And now I'm going to hand over to Salman to take us through the current position with the Indian Data Protection Bill. Salman, over to you.
Thank you so much, Robert. And it's a pleasure sharing this webinar and conducting this webinar with you. As many of you would be aware, in India, we have had recent developments with regard to a new data protection law that is being introduced in the parliament. As of now, it's in the form of a draft bill, which is currently under discussion. I would just quickly run you through some of the major aspects of the legislation, or rather the proposed legislation, which would be very comprehensive in nature. And we can then have a more detailed comparative discussion and maybe a question and answer subsequently after Michael finishes. So as just to pick up from where from where Robert left with regard to the historical aspects, as maybe some of you are aware, the Indian proposed law is picking up much from the EU Data Protection Directive, and also from some of our previous legislations in India, technically the IT Act, which was first enacted in 2000, and subsequently amended, and then finally there was the IT rules, which currently are applicable with regard to data protection framework. There is the reasonable security practices and sensitive personal data rules, which are currently the only piece of law which directly deals with data protection in India. More recently, more specifically last year, we had a major Supreme Court decision in case of Justice K.S. Puttaswamy versus Union of India, wherein a constitution bench of the Supreme Court decided that right to privacy was part of the fundamental right. And this was a long drawn battle because the original case was filed way back in 2012. And it took them quite some time to finally declare right to privacy as a fundamental right. That set the ball rolling, and the Supreme Court observed, as many of you would see, that there was observation by the court that the Parliament needs to examine and put in place a robust legal regime for data protection in India. The creation of the regime requires careful and sensitive balance between individual rights and interests and the legitimate concerns of the state. Subsequently, there was a committee, a high-level committee that was set up, which was known as the B.N. Sri Krishna Committee, for drafting a free and fair digital economy, protecting privacy and empowering Indians. This was supposed to be the primary mandate of the Justice Sri Krishna Committee. And the committee, as such, brought in its recommendations and proposed a draft bill, which was known as the Personal Data Protection Bill, which was recently made public just a couple of months back. So as of now, the process as it stands is that the government is going through a consultation and public comments have been invited. There has been a lot of public debate, and more recently we have had two US senators actually making an open letter to the government of India to look at some of the provisions which are more related to data localization. Next, please. Moving on to the proposed legislation itself, some of the most important aspects is the fact that very much following on the EU GDPR, it gives extraterritorial jurisdiction, and it's not only applicable to businesses in India or that are carried on in India, but also entities that are offering services and goods to data principals within India. Now, talking about data principles, I may highlight here that the Indian legislation, in a little deviation from the EU GDPR, actually treats data owners as data principals. It defines them as data principals and data processors as data fiduciaries. So that's a small distinction between the two legislations. Moving on, it also actually makes any activity which is involves profiling of data principals within Indian territory also applicable and falling under the purview of the proposed legislation. Can we move on? Next. Some of the major and most controversial provisions in the new proposed legislation are dealing with cross-border data transfers and the requirements of data localization. On that front, there are actually restrictions under Section 41 of the proposed legislation, which mandates that all data relating to individuals, which has been classified as critical personal data, cannot be processed outside India. It has to be compulsorily stored in India and processed in India exclusively. However, as provisions of Section 40, subclause 1, do provide that certain personal data where with the consent of the data owner can be processed outside India. However, in that case as well, at least one copy of that data has to be stored within Indian servers and in India. The central government actually also can determine categories which are of sensitive personal data, which are of critical nature to the country, and that data has to be stored compulsorily in India and cannot be processed outside. However, there are certain exceptions, more specifically relating to health and in certain other emergency services, where the central government may approve transferring of critical data outside India. Next. So the conditions in which the personal data can be transferred outside India are where there is a standard contractual clauses or intra-group schemes that have been approved by the authority. In this particular case, the proposed bill provides for creation of a data protection authority as well. I'll be discussing that more in detail later on in the presentation. But these standard contractual clauses or schemes involving data transfers have to be approved by that authority. There are also adequacy determination requirements wherein the central government can identify and actually determine and give certain leverages to sectors, certain countries and international organizations, in which case such data can be processed outside. Where, of course, again, in emergency services, it has been permitted to transfer data outside India, and where data principal has specifically consented to transfer of personal data outside India, of course, where there has been additional approval by the government. And in case of sensitive personal data as well, however, which is not critical, can be transferred and processed outside India, but with the consent and approval of the government. Next. So the concept of data fiduciaries, as I was talking about, it actually replaces the concept of data controller in Europe. So this is a small variation in terms of the terminology between Europe and the Indian proposed law. It is the entity that basically decides on the nature of collection and on the purpose of collection. There is also a further distinction wherein certain entities have been identified as significant data fiduciaries, and these are entities that process huge volumes of data. And in all cases, for processing of data by data fiduciaries, there has to be a valid contract and consent requirements. Next. The concept of privacy by design, as in Europe, is very much applicable in India, and this is something that we have directly, I could say, bodily lifted from the European legislation. And as in Europe, there are requirements which need to be implemented, whether it's in the form of implementation of security privacy policies, or in situations where data security obligations are applicable on data fiduciaries. Processing has to be fair and reasonable. The principles of collection and purpose of limitation apply unless specifically exempted. Principle of transparency apply from time to time for collection of data at various points. Data fiduciary is obligated to provide data breach notices as well. Obligations with regard to data quality and storage of limitation are also applicable on data fiduciaries. Personal data breach notifications, as I mentioned earlier, are as well applicable on data fiduciaries. However, there is a small variation from the European legislation, where in India, the notifications obligatorily have to be provided to the Data Protection Authority, but not specifically to the data principals, except in cases where there has been damage which has been caused by the breach in question. Further, processing of personal data using big data analytics, where purpose of processing is not known at the time of collection and cannot be reasonably communicated with data principal, can be undertaken only with specific consent. Next. Finally, of course, the law also provides for regulation and enforcement. As I mentioned earlier, there is a provision for setting up of a data protection authority. Ideally, this authority consists of our chairman, and there are 6 members that are appointed by the central government. Besides, there is also an adjudicatory officer that has been proposed in the authority. And all appeals from the adjudication officer actually lie at the appellate tribunal, which has also been provided for in the proposed bill. And appeals from the tribunal would lie directly with the Supreme Court of India. The tribunal, as such, also consists of a chair and such other members as the central government may identify and notify in due course. So that's with regard to the composition and the hierarchy of the Data Protection Authority and the appeals. The Data Protection Authority, as such, is obligated to perform the monitoring and enforcement of the provisions, legal affairs, policy, and setting up of standards, research and awareness, and inquiry and grievance handling and adjudication, as mentioned. Next. In terms of the offenses and punishment, in India, we follow very much the European model. Again, offenses are punishable with imprisonment of 3 to 5 years, depending upon whether the relevant offense is an intentional reckless act or damage has been caused with knowledge as such. Penalties have actually been laid down under Chapter 11. Provide for fine, and very much like Europe, in the EU GDPR, we have penalties ranging from 2% to 4% of the total global turnover. In terms of Indian rupees, they range from Indian rupees 5 million to about 15 million, and data principals can claim compensation not only from the offender, but also from data fiduciaries in case of harm that has been suffered by them as per provisions of Section 75 of the Act. That's a quick overview, and can we move on to the next? I'll hand over now to Michael.
And Salman, just before Michael presents, I've got 2 or 3 questions for you. So if you don't mind, if you're around at the end, we'll do questions when Michael finishes.
I'll be happy to take them now. If you want me to take them all together after Michael finishes, I can do that.
Yeah, we'll get to the end. Okay, sorry, Michael, over to you.
Very good. Thank you very much. Can we go to the 3rd slide, I think, on my portion? The next one, please. The one right before this, please. Yes. No, right before. Yes, here it is. We've got it. Just a comment before I move into my part of the program. It is interesting to me, it may be to many of you, that we have started with Robert's discussion of the supranational law enacted in the European Union, the GDPR. We then moved under Salman's auspices to a national law in India, and we now move into a very significant law adopted by a large state in the United States, which, from my perspective, is a reflection of a number of things that we'll get into, but immediately it is a reflection of the kind of sectoral and fragmented approach the United States has generally taken to privacy law and privacy regulation, albeit in the fifth largest economy in the world. The California Consumer Privacy Act of 2018 is indeed the most comprehensive consumer privacy law of its kind ever enacted in the United States, setting forth rules for companies that buy, collect, transfer, and sell consumer data. It is called by some an American GDPR, and indeed there are many parallels and similarities with various articles in the GDPR, although it is not nearly comprehensive as the General Data Protection Regulation. How did this law come about? If you look at the preamble, the Act cites the recent Cambridge Analytica incident in which the personal data of millions of Facebook users was compromised as a significant impetus for the legislation. And it's also the case that the drafting and enactment of the Act rushed to prevent an even more far-reaching measure from being on the November 2018 California general election ballot as an initiative. The law that is not going to be on the ballot is far more extensive than this law, although the Act itself is broader than anything we have ever seen, I think, in the United States. Unlike the GDPR and unlike the proposed Indian law, the Act does not create an independent data authority of any kind. Rather, public enforcement is in the hands of the California Attorney General, and as we'll see shortly, the Act also permits a private right of action. If we can go to the next slide, please. Salient points. The Act is effective on January 1, 2020. It has recently been amended to push back enforcement for several months. For my purposes and for the purposes of many practitioners and companies which need to comply, compliance does require effectively a data mapping and record keeping as to what has now becomes the 12-month look-back period for consumer requests. In this respect, this is very much akin to Article 30 of the GDPR, the record of processing activities. What it means effectively is that while the law is effective in 2020, in my view and in the view of many of my colleagues, this mapping of the personal data that covered organizations have in their environments has to start relatively soon. Because mapping, as many of us find, is an arduous and time-consuming and imperfect process. But if one begins to get requests from data subjects in California residents, right after the law goes live, there is this 12 look-back period, and in order to comply, a covered entity is going to have to be able to access that data from 12 months back. I mentioned the Act authorizing a private right of action as data is compromised as a result of a data breach. The damages and penalties created by the Act are very significant. The statutory damages in a consumer civil suit is limited to the greater of $100 to $750 per consumer per incident, although those damages are available in connection with a private right of action if the personal data is compromised as a result of a data breach. And for non-private right of action claims, the Attorney General may seek very, very significant violations, and you can see in certain kinds of environments, these damages and numbers can accumulate very, very quickly and become extremely large. Can we get on to the next slide? Who must comply? The Act applies to for-profit businesses that collect and control the personal information of California residents, do business in California, and have annual gross revenues in excess of $25 million, although it is unclear at this point whether these revenues are California-generated revenues or whether they are worldwide revenues. Or receiver disclose the personal information of 50,000 or more California residents, households, or devices, and that indicates another issue we'll get to in a couple of slides, on an annual basis, or derives 50% or more of their annual revenues from selling the personal information of California residents. This coverage is interesting, and I think for a lot of companies ominous, because what it can effectively mean for some businesses is that even if the business's gross revenues are not in excess of $25 million, it's relatively easy for a smaller entity to receive information on 50,000 or more California residents, given the size of the state and the way many operate. Another interesting aspect of the Act is that it also draws in corporate affiliates of covered businesses that share their branding, which means that it's very difficult under the Act, although this will likely play out in the regulations that are adopted sometime before the middle of 2020, and also in the lawsuits that inevitably will pop up as a result of this Act, what this precisely means. You know, the concept of corporate affiliates and who in a corporate family is covered. Many people are looking at this as a way to essentially stop the gaming that can potentially occur when corporations or corporate families set themselves up in a way in an attempt to evade coverage by the law. There are a number of exemptions. The exemptions specifically include the Gramm-Leach-Bliley Act, the California Driver Privacy Protection Act, the California Financial Information Privacy Act. None of these are covered by the Consumer Privacy Act. HIPAA data is exempt from the Act, and there are a couple of other privacy regimes. The estimates that we have seen for the number of companies that may have to comply with this Act worldwide is in the neighborhood of 500,000 for-profit entities. So the impact of the Act is going to be extremely extensive. It's going to be worldwide. There is some issue about the extraterritorial enforceability of the law. My colleagues and I are sure that that's going to develop as the law plays out. But you know, again, what I see here is that we've got a very significant law in a very large state, which is a very large economy, which as a result is going to bear upon a number of different companies throughout the world. The concept of personal information, if we can go to the next slide, please. The concept of personal information under the Act is extremely significant. As I say in the slide, the definition is very broadly framed. It's somewhat similar to GDPR Article 4, and it includes information that's identifiable to a household, not necessarily a consumer. But if you go through the Act and you take a look at some of the examples that are used, you've got IP addresses, metadata, device identifiers, online tracking technologies, probabilistic identifiers, all of this in an attempt to broaden the definition of personal information and therefore put real teeth into the rights that are conferred upon data subjects in California. I will also note that the definition of personal information in the Act is, I think, significantly broader than the way personal information is defined in the California Breach Notification Law in our California Civil Code. The Act does not apply to de-identified personal data so long as the de-identification meets the Act's very strict standards, or to aggregated consumer information, which also is defined strictly by the Act. That, I think, is going to be an interesting aspect of enforceability. Companies that take the position that certain information is not covered by the Act because it's been de-identified or it's been aggregated. Those of you who practice with the GDPR understand that there are numerous challenges with respect to effective de-identification and anonymization. Such questions have even arisen in the European Union whether really anonymization is possible in order to escape coverage by GDPR. I suspect we'll have the same kind of dialogue and the same kinds of challenges in connection with the Privacy Act. The compliance strategies, which we'll get into in a slide or two, really carefully need to consider the types of personal information being collected and be sensitive to the many kinds and sources of data that will fall within the Act's definition. Again, and it's really worth emphasizing, this Act is obviously new. It's obviously extremely broad in its coverage and intended to be extremely broad in its coverage. I point out a little later in my part of the presentation that, like all of the other significant laws in this area, this one's undoubtedly going to create some compliance fatigue. We move on to the slide, what new confer. So we're really getting into the meat of the Act here, and the rights are significant. You've got the Act giving consumers defined as natural persons who are California residents 4 basic rights, although in fact, if you look through the Act and some of the commentary, you'll see more than 4 basic rights, but 4 basic rights, and that is the right to know through a general privacy policy with more specifics available what personal information a business has collected about them, where it comes from, what it's being used for, whether it's being disclosed or sold, and to whom it's being disclosed or sold. Interestingly, there's no real privacy by design or privacy by default aspect of the California Act as we have in the GDPR. A parallel, I think, to the rights that are being conferred on California residents can be seen in, I would say, Chapter 3 of the GDPR, Articles 12 to 23, the various rights that data subjects have. Clearly, the right to opt out is one of the most significant rights conferred. The right to opt out of allowing a business to sell their personal information to third parties, or significantly for consumers who are under 16 years old, the right not to have their personal information sold absent their parents opt-in. The right to have a business delete personal information with some exceptions, and significantly the right to receive equal service and pricing from a business, even if a data subject exercises their privacy rights under the Act. So, folks, you've heard me use the expression data subject, which I think bespeaks, the GDPR work I and my colleagues have been doing for the last year plus. We should call them consumers and California residents under the Act. If we can go on to the next slide. If you look at the Act, it becomes immediately clear that the Act is designed to put all of these rights into practice. The Act requires that companies make disclosures to consumers via their privacy policies at the time the personal data is collected. There is, I suppose you could put it, a significant measure of accountability, somewhat parallel, I think, to Article 24 in the GDPR. Businesses are going to need to disclose proactively the existence and nature of consumers' rights under the Act, the categories of information that are being collected, and significantly, very significantly, as I pointed out at the beginning of my part of the webinar, the category of personal information that is sold and disclosed in the preceding 12 months. So the Act will require companies to determine what personal data they're collecting from individuals for what purposes, and to update their privacy policies every 12 months to make the disclosures that the Act requires. This really is significant because it is going to impose upon a lot of companies who have escaped, or at least think they have escaped, regulation under the GDPR to engage in a couple of the most significant elements of GDPR compliance, which is, as I mentioned earlier, the record of processing activity, which is to essentially identify all of the data that is being collected by consumers, where the data is, who are the custodians of that data, what kind of measures are being used to store, manage, and secure that data, and the methodology to actually get at that data when there is effectively a subject access request by a consumer to determine what kind of data a company has about you, what's being done with that data, and whether it's being sold to anybody. So basically here what we have is something very similar to the GDPR if we're looking for parallels with the GDPR. If we can go to the next slide. Some likely impacts. The Act it's going to affect companies worldwide, although as I mentioned earlier, extraterritorial enforcement is an open issue that'll play itself out as the Act goes live. It may well be an impetus for other states to adopt similar laws. In fact, one of my partners suggested to me that when I begin the webinar today, I didn't do it, but I'll do it now. I should mention that not only do we have this very significant California Consumer Privacy Act of 2018, but folks, watch out what comes next, because it is thought by many that this act may be an impetus for other states to adopt similar laws, and indeed may be an impetus for the U.S. federal government to move toward a national consumer privacy law, something akin to the Obama administration's Consumer Privacy Bill of Rights. There is no question, given the experience that I and my colleagues have had over the last few years, this is likely to give rise to even more compliance fatigue. Companies continue to struggle with the GDPR. As Robert pointed out in his portion of the presentation, we will have the e-privacy regulation to deal with as well. I suspect that other states will be contemplating the adoption of laws of this kind. And then last but not least, particularly because this is California, there will be significant regulatory enforcement and consumer lawsuits. If we can go to the next slide, please. Apropos my comment about other legislation being prompted by this one, recently the U.S. Chamber of Commerce is lobbying Congress to pass an Omnibus Privacy Act. The Internet Association has released a proposed framework for federal legislation. And last but not least, the Interactive Advertising Bureau called for a federal omnibus law to preempt the act. There is a kind of a swell of activity for something to be adopted in the United States at the federal level, something that is predictable throughout the 50 states and our various territories in a way that the California Act simply does not accomplish. Because it is enacted and enforceable by a state. So we go on to the next slide. What should companies do now? And this for a practicing lawyer and for anybody managing a business is for me the most significant set of takeaways about the act. So what should companies do now? Well, preeminently, they've got to adopt suitable and proactive compliance policies and associated templates that will withstand consumer, lawyer, and regulatory scrutiny. Those of you who have been involved in GDPR compliance will not find this new. I've mentioned the Article 30 record of processing activities. GDPR compliant companies are already dealing with subject matter access, individual rights policies, and the templates being used to respond to subject matter access, access requests. Companies will have to establish protocols to address consumer requests under the Act. This is going to be critical because very much as in the European Union when GDPR went live, there will be many test cases with people simply sending in subject access requests to test whether an organization is in real compliance. And it's going to be, from my experience, not necessarily easy to establish these protocols, not so difficult to draft a policy perhaps, but for workable protocols to be established so that when a subject access or consumer request is actually made, a company can reliably and has a reliable documentable means of going through its systems, determining what data it has on this consumer who's making the request, what's happened to that data, and if necessary, doing things like deleting that data. You know, interestingly, and the lawyers on the line, I think, who have had this experience will agree with me. A lot of companies talk about this, but it's still interesting to me to see so many organizations unable to smartly comply with these kinds of requests. And under the California law, very much like under GDPR, a sine qua non of the law is that if the request is made, you've got to be able to respond to it. Covered companies are going to have to make sure that consumer data is effectively mapped, and the mapping covers the 12-month look-back period. You know, last but not least, and for me, this is probably the most significant takeaway, because this is an absence or a gap that I see in a lot of different organizations, is someone needs to be in charge of this process. It's okay to have committees. It's okay to have a number of management and administrative level fingerprints on a company's process, a covered company's process for coming into compliance and administering its compliance. At the end of the day, very much like GDPR compliance, very much like compliance with any other information security or security regime, somebody has to be in charge. I can tell you from my experience representing organizations, if there's nobody in charge, there will be problems. And that concludes my part.
Thank you, Michael. And I'm just going to wind up with that can breach or that can breach, because what I think is starting to get every board's attention is the reputational damage and the cost of getting it wrong, and not having in place the compliance and the preventative measures that both the Californian law will drive, as will the law in India. And the reason I use the dam is that we are starting to see in the UK, at any rate, and under GDPR, the notion of a quasi-class action, which could be based on showing no more than emotional distress. In other words, no financial loss, but the mere loss of sleep, of worrying where the email address and the personal data has gone to. And I can see that we will have, and indeed it is already starting, no win, no fee type actions on behalf of not hundreds, but millions of those affected by major breaches. And that is going to be, you know, one battle that a company will be fighting, along with having to notify the breach to the regulator, along with having to notify individuals, along with having to deal with subject access requests. And it will, it's a C-suite issue, as Michael's already said. But I happen to think that maybe having to invest in complying with California and doing the data mapping, or having to invest in complying with India and understanding the different players in the ecosystem, like the processor, like the fiduciary, the multinational, will be a good return on investment, because we are all heading in the same direction. Salman and Michael, we've got one or two questions that have come in. And Salman, I'm going to throw the first one to you. It was two separate questions, but I'm lumping them together. The how do you determine when a fiduciary is significant under the bill?
Well, thank you so much, Robert. I think I will just quickly answer the first, or rather the latter part of the query first. So, as of now, what is a significant fiduciary has not been defined per se, because the proposed legislation just simply says that it would be notified by the government as and when the government notifies it. But primarily, the entity that is handling significant large volumes of data, personal data, or processing personal data would be treated as a significant fiduciary. In terms of what exactly a fiduciary means, is basically Section 213, which is Section 2, Clause 13, defines a fiduciary as any person, including the state or a company, any juristic entity, or any individual who alone or in conjunction with others determines the purpose and the means of processing of personal data. So that is the specific definition of a fiduciary. And as I mentioned earlier, the government has not exactly given any notifications yet what would be treated as.
So, Michael, question is, do you think the Californian law will be changed before it is finally enforced?
Yeah, did I hear your question? I mentioned that California law is likely to be changed again.
Okay, but do you still think that is going to be the fifth deadline?
Well, let me answer the question that I think I heard. The law has been amended once already, in main part for clarifying purposes. It is likely to be amended for clarifying purposes again, although I can't tell you, as we talk today, what those amendments will be. I know that the law was very hurriedly put together in order to make sure that the larger initiative was not going to be on the ballot this coming month. So there are some flaws in the law. There are some unanswered questions. And so there are a number of things that will play out both in the legislature as time goes on, and also by way of the regulations that are going to be adopted for purposes of enforcement. But I would caution anybody who has decided to wait or advise clients to wait for considerable periods of time before doing anything. The essence of the law is highly unlikely to change unless, of course, there's a preemptive law, a preempted law enacted by the federal government. Those elements of the law, what the consumer's rights are, when does a company have to comply with those rights? What does a company have to do in terms of transparency and accountability? Is it possible that those will be diminished? Sure, I suppose it's possible, but very, very unlikely. Again, I say, unless there's a preemptive federal law. The whole idea of this law was to confer upon California residents, California consumers, the right to own information about themselves. So while there may be some efforts to diminish the scope of those rights, by way of lobbying efforts and an amendment process, in my view, it's highly unlikely that there will be any significant diminution, if at all, in the scope of those rights. If anything, I would say that the rights perhaps will be increased. Same thing with the actions needed to be taken by businesses. Because of the length of the webinar, I wasn't able to get into it, but there are a number of different things that businesses have to do, in addition to determining what kind of data they collect. They've got to have, two methods for consumers to submit requests, including a toll-free number. Policies have to be, looked at, at a minimum, every 12 months. Websites have to have clear and conspicuous link entitled "Do not sell my personal information," a link that takes consumers to a web page where they can opt out. And businesses have to ensure that all individuals charged with handling consumer inquiries are informed of the statute's requirements. Not necessarily that California law is going to require the adoption of a DPO requirement, as data protection officer requirement, as the GDPR requires. But, and this is not just happening in California, I think that the law, as it's developing in this country, requires someone to know, someone to be in charge. I don't think that we're going to go back to the regime or stay very long in the regime where people can say, I just didn't know, I didn't realize, or I didn't know consumers had these rights, or I didn't realize that we as a company had to do this. I think those days are long gone. Robert, I think I probably, assuming I even answered the question you asked, I think I probably over-answered it.
Yeah, that's absolutely fine. And I've got another one, Salman, for you. Do you think that there can be far-reaching consequences of the draft bill allowing the state to process data in the interest of security, given the weak safeguards? It would really be a threat to privacy?
Robert, I'm sorry. I think you'll have to come again because I couldn't pick that up.
The question was, do you think that there can be far-reaching consequences of the bill allowing the state to process data in the interests of security? Will that not be a threat to privacy?
I surely do think that there would be far-reaching consequences, and actually there have been already examples of state processing data and probably not handling it well. And that's an example. A recent example is all the controversy and data breaches involving the Aadhaar, the Aadhaar project in India, which is the National Identification Card project in India. And there have been major breaches, and it's all being handled by the state. While the state has been claiming that they have a foolproof security setup, but every now and then for the last year or so, we have had several data breach controversies around that, and I think that's just a very clear example of state, state handling of personal data leading to breach of privacy of individuals in India.
Okay, thank you. We've reached the hour, and so thank you for those of you who sent questions in. I am sure that both Michael and Salman will be more than delighted to hear from you individually. If you want to email them, if you've got any other questions, please forward them through to me as well. The webinar, as you can see, has been recorded and will be available on our website on our cookie jar blog. So please look for that in 5 days' time. Very grateful to everybody for being on the call. Particularly want to, on your behalf, thank Michael and Salman for their input at difficult times of the day for both of them. I apologize to one or two of you that there were some slight sound issues on this particular event. Our next event will be on the 27th of November, when we will be doing a webinar with the Data Protection Network on how to effectively manage subject access requests under GDPR. So do look for that on our website. From me and from Nilisha on technology, thank you, and we look forward to being with you on another occasion. Bye-bye.